When a marriage breaks down and the parties decide to divorce, all that is owned by each person and what has been acquired during the marriage must be divided up. It matters little who owned or earned it. It will be considered a matrimonial asset, available to fall into a pot for division between the parties. The courts have wide powers which they will exercise to make a fair and equal division of the family assets. In so doing, they will consider all the circumstances of the case and have special regard to the welfare of minor children of the family. The powers of the court include making orders that one spouse pays maintenance to the other, pays a lump sum, or transfers property, or the benefit of a pension to the other. When deciding what order to make, the court is specifically required to consider whether it is appropriate to order a clean break. This will bring to an end the couple's financial obligations to each other. Even where this is not appropriate, consideration must be given to whether maintenance should end after a specified period. The court is further required to have regard to the statutory provisions in Section 25 of the Matrimonial Causes Act. These state that the court must take into account the income and earning capacity of the parties both now and in the foreseeable future, and take into account each spouse's financial needs, obligations and responsibilities. The duration of the marriage and the standard of living enjoyed will be a relevant factor, as will the age and any physical or mental disability of the spouses. It is specifically stated that contributions to the well-being of the family, such as giving up a job to look after children or giving up other benefits such as pension rights, must be taken into account during the financial division process. There will often be disputes around the matrimonial home. Who is to live there and what is to happen with it? It makes little difference as to whose name the property is in. The court can order a sale and then decide how the money will be divided, or they can order a transfer of the property from one spouse to the other. If a sale is ordered, it is often postponed if there are young children until they complete their education and can be independent. It is only then that the house will be sold and the proceeds divided. Any unfairness towards a spouse who is losing his or her home can be compensated for by ordering the other to make a lump sum payment to adjust the entitlement to a share of the equity in the house. An important consideration will be whether the net proceeds of sale of the matrimonial home is enough to enable each of the spouses to buy an adequate property of their own. Even if one spouse wants to stay living in the home, it may not be practical if they are unable to maintain the mortgage. An order for sale will be particularly likely when there is a short marriage and no children. However, where there are children, the court will not want to cause disruption to their lives by ordering a sale and forcing the children to relocate. Although the courts have wide powers to force settlements on parties, they will always encourage them to reach an agreement themselves, using mediation if appropriate. When agreement is possible, the court will then make a consent order, which gives the agreement legal effect and will be binding. They will only do so, however, when the terms agreed are fair and comply with the statutory guidelines. LegalZone lawyers are experienced in dealing with the financial side of divorce and will be happy to advise and discuss your individual case. Click on the button at the top of our website or the link in the description of this video to get in touch now. LegalZone. Getting legal advice has never been so easy.